Hi. Welcome to Jurisprudence Philippines. My name is Prudence. In this video, we're going to discuss one of the topics under persons and family relations. In particular, we'll talk about the essential requisites of marriage. And we'll also answer some bar questions related to the topic. But first, let us define what marriage is. According to Article 1 of the Family Code, marriage is a special contract of permanent union between a man and a woman, entered into in accordance with law, for the establishment of conjugal and family life. It is the foundation of the family, and an inviolable social institution, whose nature, consequences, and incidents are governed by law and not subject to stipulation, except that marriage settlements may fix the property relations during the marriage, within the limits provided by this code. Section 2, Article 15 of the Constitution states that marriage, as an inviolable social institution, is the foundation of the family and shall be protected by the state. In Goitia v. Campos Rueda, marriage is an institution, the maintenance of which the public is deeply interested. It is a relation for life and the parties cannot terminate it at any shorter period by virtue of any contract they may make. The reciprocal rights arising from this relation, so long as it continues, are such as the law determines from time to time, and none other. In Beso v. Daguman, marriage is an institution in which the community is deeply interested. The state has surrounded it with safeguards to maintain its purity, continuity and permanence. The security and stability of the state are largely dependent on it. It is in the interest and duty of each member of the community to prevent the bringing about of a condition that would shake its foundation and lead to its destruction. The incidents of the status are governed by law, not by the will of the parties. What are the requisites of marriage? There are two kinds of requisites. The essential requisites are under Article 2 of the Family Code. The formal requisites are under Article 3 of the Family Code. Article 2 states that no marriage shall be valid unless these essential requisites are present. 1. Legal capacity of the contracting parties, who must be a male and a female. And 2. Consent freely given in the presence of the solemnizing officer. Now, what is legal capacity? Legal capacity of the contracting parties involves 1. Age. The contracting parties must be at least 18 years old. 2. Sex. Marriage must be between a male and a female. And 3. Absence of any impediment. See Article 5 in relation to Articles 37 and 38. Article 5 of the Family Code states that any male or female of the age of 18 years or upwards, not under any of the impediments mentioned in Articles 37 and 38, may contract marriage. Limited emancipation. A. Parental consent is needed for parties between 18 to 21 years old. Article 14 of the Family Code states that in case either or both of the contracting parties, not having been emancipated by a previous marriage, are between the ages of 18 and 21, they shall exhibit to the local civil registrar the consent to their marriage of their father, mother, surviving parent or guardian, or persons having legal charge of them, in the order mentioned. Under Article 45 of the Family Code, a marriage is voidable if the party in whose behalf it is sought to have the marriage annulled was 18 years of age or over but below 21, and the marriage was solemnized without the consent of the parents, guardian or person having substitute parental authority over the party, in that order. Unless after attaining the age of 21, such party freely cohabited with the other and both lived together as husband and wife. In other words, if no parental consent is obtained, it makes the marriage voidable. Under Article 47, if no parental consent is obtained, the action for annulment of marriage must be filed by the following persons. 1. By the party whose parent or guardian did not give his or her consent. within 5 years after attaining the age of 21. Or 2. By the parent or guardian or person having legal charge of the minor. At any time before such party has reached the age of 21. Under Article 15 of the Family Code, any contracting party between the age of 21 and 25 shall be obliged to ask their parents or guardian for advice upon the intended marriage. If they do not obtain such advice, or if it be unfavorable, the marriage license shall not be issued till after 3 months following the completion of the publication of the application therefor. In other words, the absence of parental advice does not make the marriage void or voidable. It only affects the release of the marriage license to be postponed until 3 months from the complete publication of the application. Under Article 16 of the Family Code, in the cases where parental consent or parental advice is needed, the party or parties concerned shall, in addition to other requirements, attach a certificate issued by a priest, imam, or minister who is authorized to solemnize marriage, or by a marriage counselor duly accredited by the proper government agency, to the effect that the contracting parties have undergone marriage counseling. Failure to attach said certificates of marriage counseling shall suspend the issuance of the marriage license for a period of 3 months from the completion of the publication of the application. Issuance of the marriage license within the prohibited period shall subject the issuing officer to administrative sanctions. But this shall not affect the validity of the marriage. In other words, marriage counseling is a requirement for the issuance of a marriage license in cases where the parties need parental consent or parental advice. This is to enable the parties to find out if they are compatible before they get married. Again, the absence of such has no effect on validity of the marriage. However, this will suspend the issuance of the marriage license for 3 months from the completion of publication of the application. If they get married during the 3-month period, the marriage will still be valid but civil and criminal liability may attach. Number 2. Sex. Remember that under the Family Code, marriage must be between a man and a woman. Under Jones v. Hallahan, 2 females are incapable of entering into marriage. There is no constitutional protection of the rights of marriage between 2 persons of the same sex. In Republic v. Kagandahan, sex is determined at birth. Marriage between 2 people who had the same sex at birth is invalid, even if one changes sex by law. In Silverio v. Republic, changing of sex in one's birth certificate on the basis of sex reassignment shall be denied. Otherwise, it would result in confusion, and would allow marriage between persons of the same sex, which is in defiance of the law, as marriage is a union between a man and a woman. But when the change in sex happens naturally, as when the person has congenital adrenal hyperplasia, or is biologically or naturally intersex, the determining factor in their gender classification would be what they, having reached the age of majority, and with good reason thinks is their sex. Change in name and sex as registered is here allowed. The legal impediments which may affect legal capacity are those mentioned in Articles 37 and 38 of the Family Code. Thus, the contracting parties are not legally capacitated to marry each other. Under Article 37, marriages between the following are incestuous and void from the beginning, whether relationship between the parties be legitimate or illegitimate. A. Between ascendants and descendants of any degree. And B. Between brothers and sisters, whether of the full or half-blood. Under Article 38 of the Family Code, the following marriages are void for public policy. A. Between collateral blood relatives, whether legitimate or illegitimate, up to the 4th civil degree. B. Between step-parents and stepchildren. C. Between parents-in-law and children-in-law. D. Between the adopting parent and the adopted child. E. Between the surviving spouse of the adopting parent and the adopted child. F. Between the surviving spouse of the adopted child and the adopter. G. Between an adopted child and a legitimate child of the adopter. H. Between adopted children of the same adopter. And I. Between parties where one, with the intention to marry the other, killed that other person's spouse, or his or her own spouse. Now, what is consent? In People v. Santiago, the consent must refer to the contracting party's bona fide intention to be married to the other. For example, the intention to make the woman his wife. Consent is different from motive. A freely given consent requires that the contracting parties willingly and deliberately enter into the marriage. Motives, such as acquiring foreign citizenship as in Republic versus Elbios, or out of reverence for the other spouse's parents as in Republic versus Romero, are immaterial for the determination of the validity of marriage. Under Article 4, absence of consent renders the marriage void. 1. Under Article 35, Paragraph 5. If there is a mistake as to the identity of the other party. For example, 1 marries his fiancée's twin by mistake. 2. Mistake as to the legal consequences and nature of the marriage ceremony. For example, thinking the ceremony is only a joke, pretend, or play acting. In Republic versus Elbios, a marriage in jest is a pretend marriage. Legal in form but entered into as a joke, with no real intention of entering into the actual marriage status, and with a clear understanding that the parties would not be bound. The ceremony is not followed by any conduct indicating a purpose to enter into such a relation. Marriages in jest are void ab initio, not for vitiated, defective, or unintelligent consent, but for a complete absence of consent. In People versus Santiago, it was held that the marriage entered into by a person whose real intent is to avoid prosecution for rape is void for total lack of consent. Here, it was the intent of the accused, not the victim of rape, whom he married under duress, that was considered. The accused did not intend to make the victim his wife. He merely used such marriage to escape criminal liability. Under Article 4 of the Family Code, defective consent makes the marriage voidable. A marriage may be annulled for any of the following causes, existing at the time of the marriage. 1. Under Article 45, Paragraph 2. Either party was of unsound mind. 2. Under Article 45, Paragraph 4. Consent was obtained by force, intimidation, or undue influence. 3. Under Article 45, Paragraph 3. The consent of either party was obtained by fraud, unless such party afterwards, with full knowledge of the facts constituting the fraud, freely cohabited with the other as husband and wife. Article 46 provides the circumstances which constitutes fraud. A. Non-disclosure of a previous conviction by final judgment of the other party of a crime involving moral turpitude. B. Concealment by the wife of the fact that at the time of the marriage, she was pregnant by a man other than her husband. C. Concealment of sexually transmissible disease, regardless of its nature, existing at the time of the marriage. Or D. Concealment of drug addiction, habitual alcoholism or homosexuality or lesbianism existing at the time of the marriage. No other misrepresentation or deceit as to character, health, rank, fortune or chastity shall constitute such fraud as will give grounds for action for the annulment of marriage. What is the effect of the absence or the defect of the essential requisites on the marriage? Article 4 states that the absence of any of the essential or formal requisites shall render the marriage void ab initio, except as stated in Article 35, Paragraph 2 of the Family Code. Where marriages solemnized by any person not legally authorized to perform marriages are still valid, as long as they were contracted with either or both parties believing in good faith that the solemnizing officer had the legal authority to do so. On the other hand, a defect in any of the essential requisites shall not affect the validity of the marriage, but the party or parties responsible for the irregularity shall be civilly, criminally and administratively liable. If you learned something new from this video, please like and subscribe. Thank you for watching.